Building A is unoccupied and identical building B is vacant. Which is the higher risk?
B is the higher risk
Why?
because there's no items or people in the building, or
Yep.
no physical like desks or whatever.
Yep, exactly. And what's unoccupied?
When just the people are not in the building.
Exactly. Right. And then we'll talk about V and MM, right? Vandalism and malicious mischief. We'll talk about that coverage today. That's where these terms come into play, right? Insurance companies can cancel policies when a building's vacant, not when a building is just unoccupied, right? Unoccupied means there's no people, vacant means no people and no property. So vacancy serves as the higher risk. Mary's house was badly damaged by a hurricane. A claims representative from her insurance company came out to inspect the damage and put a value on the loss. What Mary thought the value of her property was and what the claims representative is stating the value to be do not match. Mary is extremely upset over this dispute in value and wants another opinion. In accordance with Mary's rights under the insurance policy, she can request what option to get a second opinion on her loss value?
D, third party adjuster.
A, appraisal.
Appraisal.
Yeah.
Yep. And again, these all kind of sound like they could be right? Third party adjuster sounds like the obvious choice. It's called the appraisal clause or the arbitration clause, right? In homeowners, it's called the appraisal clause. In auto, it's called the arbitration clause. And what that says is if the insured disagrees with the handling of a claim from the insurer, they can both call in an appraiser. What happens if they still can't come to an agreement?
They call an umpire.
They call in an umpire appraiser. Good. And what does that umpire do? Do they make a suggest it, like, here's what I think, or do they make that final decision?
They make the final decision.
The final binding decision, right? So this is all part of the appraisal clause or the arbitration clause. Here, because they're talking about a home, it would be the appraisal clause. Casey was a victim of an automobile accident in which substantial but not total damage was done to her car. Cassie sued the party at fault and was rewarded $7,525 to cover the cost of her vehicle and other costs she incurred due to this accident. What type of damages was Cassie compensated for?
D.
It is D. Yep. Compensatory damages, right? Paying for the actual losses suffered. Sarah was a victim of a car accident in which she severely injured her right leg. It took Sarah months of therapy to recover to nearly 100%. While in court to settle her claim, the judge offered Sarah $15,000 for her pain and suffering as a result of the accident. What type of damage was Sarah compensated for?
A, general.
This is general, right? So pain and suffering, humiliation, mental anguish, right? All of that is your general damages. Here, where they're paying for the actual loss sustained, that's compensatory, right? I think they're actually compensating, right? They're compensating for the loss suffered, compensatory damages. Lindsay was driving home after a night out with friends. She had been drinking heavily and should not have been operating a vehicle. Lindsay caused a 3-car accident in which there were injuries to each driver. While Lindsay was on trial for her actions, the other drivers were each rewarded $50,000 simply due to the fact that Lindsay broke the law and caused significant pain and suffering to the other drivers. This compensation awarded to the claimants is known as what form of damages?
Is it B, punitive damages?
Yep, it is punitive damages. That's a significant amount of money, right? They're setting an example out of Lindsay, right? She did something extremely negligent, right? She was drinking and driving, right? She caused injuries to 3 other people because of her negligence. The purpose of this is they're setting an example out of her, right? They're punishing her and rewarding the people that were injured, right? That's punitive. Setting an example, discouraging other people from doing that in the future. That's punitive damages. An insured causes an accident in which 3 people are injured. One person claims $50,000, the second claims $100,000, and the third claims $250,000. The insured has a combined single limit of $250,000 liability on her automobile policy. What is the sum total the policy will pay?
C.
I was going to say it's easier than it looks. Yep, $250, right? They're not going to pay anything more. You read through this, it makes you think you have to do a lot of math. You really don't, right? They're telling you the single liability limit is $250. That's your answer, right? They're not going to pay anything more than that. You would think you'd have to start adding all these totals in, 250, 150. You don't, right? Because the max they're going to pay is $250. They're not going to pay anything over that. So the answer is C. Several people were seriously injured in an accident at the insured's home. If the personal liability limit in the insured's homeowner's policy is $100,000, the maximum the insurance company will pay is.
Would it be B?
Yep, B. When do policies pay on a per person? When does that come into play? Tanya, you should know. When does that come into play?
Medical.
Medical coverage, right? Medical coverage is when it's per person, right? But when it's just talking about liability, it's just in total, right? So on a liability claim, they're going to pay $100,000, right? So C and D are out. It's not on a per person basis. So then is it plus or minus insured's defense cost? We know defense cost, that's one of those supplemental or additional payments. So it's always going to be plus the defense costs. Right, so that's when we talked in the beginning about those common policy provisions. And as we get into dwelling and homeowners and auto, we'll see those again. We'll see those supplemental and additional payments or coverages. But that's in general, you can keep that in the back of your head. Defense costs, claim costs, legal fees, anything like that. It's always going to be the claim amount plus any of those additional coverages. Paul visited a wildlife safari to see the new lion exhibit. If Paul were to enter the lion's gated area to help the safari worker with a feeding, he will not be able to sue the safari if anything wrong were to happen. Why would he lose the ability to sue?
Would that be B?
A.
A. He would assume the absolute liability in this situation. So remember, with your liability, we have three types of liability. We have strict, we have absolute, and we have vicarious. Absolute is absolutely hazardous or absolutely dangerous, right? It's a good way to think about that. Absolutely hazardous, absolutely dangerous. Does anyone remember what strict liability is? What's the one word I said? Yep, I think you just said it, Katie. Sorry, I cut you off again. What did you say?
Yeah. Products.
Products. Yep. So your strict is your products. And then what's vicarious?
Like parents and children.
Yep. Assuming
are responsible for their children.
Exactly. Yeah. Being responsible for somebody else's negligent behavior, right? Parents over children, principals over agents, employers over employees, right? Being responsible for somebody else's negligent actions, right? That's your vicarious liability. This situation, because working with animals is extremely dangerous, he assumed that absolute liability. Patricia is a 50-year-old woman who teaches at a local college. She is well known and a respected member of the community. When driving, as the sun was setting, Patricia did not turn on her car light. She caused an accident due to another operator not being able to see her car in the dark. Patricia is accused of acting in a careless and reckless manner. What is the term to define her actions?
D.
D, negligence, right? And yet again, there's a lot of what you would think would be obvious answers here, right? Carelessness, reckless action, criminal activity, right? Don't fall for what they're going to try to do to you on the exam, right? It's not these terms. The term we know, the term we've been talking about is negligence, right? Doing something that a reasonably sound person wouldn't do, right? That would be negligence, right? Missing the conduct of what a reasonably sound person would do. Circulating an oral statement that is maliciously critical or derogatory of the financial condition of an insurer is what?
A. Defamation.
Defamation, right? I think you're defaming their name. What is the result of a producer not completing their continuing education during the required time?
D, voluntary license termination.
What if the question said they were having a family emergency, they had a death in the family, and they were traveling?
B.
Still be D.
Still be D, right? Don't let them get you. They might try to give you a sob story and do what I just did. Don't fall for it. It would never be involuntary. It's always, always, always going to be a voluntary termination. Always. Who is an individual appointed by an insurer to solicit insurance or annuity applications, countersign insurance policies, or perform related services such as collecting premiums, transmitting applications for insurance, or delivering policies?
C.
Producer. Yep, producer, agent, yep, anyone that is licensed, and keyword here being appointed. All of the following are unfair claims practices, except...
Is it B?
Not B. Your keyword here being unfair claims practices. If you guys remember, there's unfair claims and there's unfair trade. So 3 of these are going to be unfair claims practices. Which one is not an unfair claims? It might be an unfair trade practice, but it's not an unfair claims practice.
Would it be D, knowingly misrepresenting relevant facts?
A, discriminating between the persons of the same class, hazard because of their race, physical handicap, religion, or national origin. What is that describing? What term?
Discrimination?
Discrimination, right? Discrimination is not an unfair claims practice. It's an unfair trade practice, right? Yet again, another thing they will do to you on the exam, right? Very easy to read through these and you're like, yeah, they're all true. That's all correct. It is, but that's not an unfair claims. It's an unfair trade. The rest of those are all related to claims, right? Attempting to settle a claim for a less than a reasonable amount. Forcing policyholders to sue reasonably higher claim payments, knowingly misrepresenting relevant facts about coverage to claimants, right? They're all related to claims except A. An insurance producer must notify the commissioner in the event of,
D dog.
yep, change in address. And how many days do you have to notify the commissioner?
30, right?
30 days. Yep, 30 days for a change in address. Good. Agent Donna, to produce more business, decides to hold a drawing for a cruise for people who purchase a new policy within a specified time. This is an example of what?
B, rebating.
Rebating, right? Exchanging anything of barter. It's going to be rebating. Yep. An individual who holds a position of public trust and confidence is a,
C fiduciary.
yep, exactly.